subsidy had become due to the petitioner. The next annexure is
So that amount was released?
in 18, in 2018.
All right, then?
So
So that you recover, that goes against the order of the High Court of payment of interest, which we have paid, and if they have recovered, then you get it recovered. That's all. It's a quid pro quo.
I wanted to draw your Lord's attention to annexure 3, my lord.
Otherwise, the court would have granted you interest at that time.
The court
That you should have asked at that time when you filed this petition.
the judgment.
See, the subsidy was required to be paid in 1996.
1990, my lord, 6
As per this judgment.
Something
What do they say in their counter? Yes, what do you say?
My lord, my friend is submitting that he had deposited 1 crore something lakh.
It may please your lordships. Lordship, this petitioner has approached your lordships for payment of interest on the delayed payment of subsidy amount, your lordships.
Subsidy amount was paid belatedly.
The lordships. It was due.
What is your right to get an interest on it?
It was the subsidy was due in 1990, lordships. Part of the subsidy was paid. Part of the subsidy they said will not be paid, lordships. I approached this honorable court. The court at the first instance directed the directed industries to decide my claim, lord. They rejected my claim. I approached this honorable court again. This honorable court said that he is entitled for interest. He is entitled for subsidy. The subsidy amount may be released to the lender, my lord. The BCCO here is. And my lord said that interest will not be charged. My lords, neither the subsidy amount was released, nor my lords, the BCCO stopped from charging interest. My lords, I have brought on record, my lords, annexure 3 to show, my lords, that as on.
Where is that order?
Annexure 2 is the
Page?
my lord, it begins at page 18, your lords. Annexure 1 is for annexure 1, page 18, your lords. And my lordships, I will show that under similar circumstances, interest has been ordered to be paid.
The order is at page 29. Where was that interest amount directed to be paid?
Lords, in this, my lords, the operative portion, my lords, will find in the result this writ application is allowed, paragraph 13, my lords, page 28. And the impugned order dated 26/4/96, to the extent it concerns the petitioner, is hereby quashed. The consequential letter communicated through memo so and so is also quashed. The respondent authorities are directed to sanction the aforesaid sum of rupees 7,74,600, being the differential amount of industrial subsidy, which shall be adjusted against the loan amount sanctioned and paid by the respondent number 5 to the petitioner. The respondent number 5 shall not be entitled to charge interest on the loan amount to the extent of rupees 7,74,600 from the date the same by way of industrial subsidy had become due to the petitioner. The next annexure is, my lord.
So that amount was released
in 18, my lord, in 2018.
All right, then?
My lords, our case is that, my lords, I had to pay the interest. My lords, I will annexure 3.
You had to pay interest on the 7,74,000?
I have brought on record, my lords.
So that you recover, that goes against the order of the High Court of payment of interest, which we have paid, and if they have recovered, then you get it recovered. That's all. It's a quid pro quo.
I wanted to draw your lord's attention to annexure 3, my lord.
Otherwise, the court would have granted you interest at that time.
The court, my lords, wanted that the release.
What the court said is that they will not charge interest on the loan amount, and they will pay you the amount. So that means no interest either. They will also not take it, and they will also not give it. That was the basic idea. And suppose if it is delayed,
I will not have.
If it is delayed, and if you have paid the interest, then it goes contrary to the judgment of the court. Get it recovered.
Lord, so when I came in contempt, Lord, they said that now we are releasing the subsidy amount in 2018. Lord, this honorable court said that there was no order for payment of interest. So the liberty maybe is given to raise that, but this contempt petition will not be the appropriate proceeding for grant of interest. So therefore, my lords, in that light, my lords, I have moved. The fact remains, my lords, they have
Fact
raised.
remains, you can't be filing successive petitions. Once an order has been passed and it does not mention about interest, a fresh writ petition would not lie for that. Show a law.
My lords, under similar circumstances, interest has been granted by this honorable.
That you should have shown at that time.
Their recent judgments, my lords, it was not at that time, my lords, I was not supposed to make this to suffer because the BCCO was not supposed to charge any interest. My lords, for a moment, my lords, may come, my lords, I may trouble you lords to come to page 31. That the subsidy amount was 7,74,000. And they raised the demand note, my lords, on 31/3/2000. The order came in January 2000, amounting to rupees 7,68,000. And thereafter, my lordships, I repeatedly, my lords, requested them that please revise this demand note. And then I have also said that I have made you excess payment because subsidy amount, if it is released, this amount would not be liable. The BCCO, my lords, have filed its counter, said that I repeatedly request the state government to release the amount that has not been released. So therefore, my lordships. And BCCO, my lords, later on in 2009, there was a policy of one-time settlement. Under that, if my lordships, I have made before judgments, my lords, which wherein, my lordships, one was.
Any judgment which says that in one judgment you don't get the interest, so you can file a fresh petition.
Not the judgments are, my lords, if the subsidy has been delayed, then, my lordships, interest has to be paid.
That you should have asked at that time when you filed this petition.
These judgments.
See, the subsidy was required to be paid in 1996.
1990, my lord, 6/2.
As per this judgment.
Lordships.
As per this judgment, it was to be paid in 96. The judgment was passed in 2000.
Yes.
So for 4 years, you were entitled for interest, as per your judgments, what you are showing,
Yeah.
which you never claimed. In your writ petition, you never claimed, or you did not go in appeal. You could have gone in LPA and asked for this extra interest, which the judge has not given you.
That order was in my favor to the extent that BCCO had.
It was, so you can't be asking that, I'll file a fresh writ petition. Not the court gave you this indulgence.
Lords, the court wanted that I should not be paid interest up to the of the subsidy.
Show us the prayer that you did not ask for interest at that time.
Of the previous writ application.
You should have. All the prayers, we don't need to look into it. All the prayers would be presumed to have been already made and answered.
That's correct.
That is.
No, the issue is, my lords, that at that time, my lordships, they were denying my subsidy.
Sorry.
They have been allowed to do. Lordships,
Petitioner,
may I request you? Lordships?
nothing further. You can't be putting anything else which you want to say.
Lords, the order of the contempt court, lordships, is that it may be raised in a fresh return.
That doesn't bind the court. It is an observation in a contempt proceedings. And observations can also not be given. Contempt court jurisdiction is limited only for implementation. No observation, no additional or subtraction in the original order.
Lords, this application was heard by a division bench. My lords, kindly see the last order, my lords.
There is a judgment of Supreme Court on this,
It's I for a moment.
arising from Rajasthan,
Lordships.
long back, that if the contempt court, while hearing contempt proceedings, cannot add or subtract
Correct.
anything else. So your correction, what you are saying in contempt,
I was saying.
is per inferium.
Lords, I moved in contempt for release of subsidy amount. Because they were, despite the order of this honorable court,
That's all
they were
right.
not releasing us.
So then it was, so your contempt stood
So,
satisfied.
my lords, the fact remains that from 1990 to 2018, my lords, for no fault I have been made to suffer, I have to pay interest, my lords, to the BCCO. If my lords directs them to refund me the interest amount that I have paid, because for a 84 lakhs loan, my lordships, I have paid them 1 crore 76 lakhs. So that is how, my lords, a grave injustice has been done to me. One technicality or other may come in the way, but my lords, the fact remains that I have been made to say, and this was a policy for promoting the industries. To the contrary, my lords, the officials of the government harassed me to the extent that it something.
What do
was-
they say in their counter? Yes, what do you say?
My lord, my friend is submitting that he have deposited 1 crore something lakh out of 86 lakhs. At the
He is
scheme of
submitting, it is
one-time
wrong.
settlement, one is government has released 15 lakh subsidy, and he has paid 17 lakh 50,000. Only
We are not here to calculate.
my lord.
We want to know from you whether you have charged interest on the 7,74,000 amount, which was specifically not allowed to you by
My
the
lord,
High Court.
my lord.
Have you charged interest on
No,
it?
my lord.
Is it your case that you have not charged?
My lord.
Show. From your counter.
In this case, my lord, I am appearing on behalf of the state, my lord. Disco I have to answer, my lord, a specific query, my lord.
Who is appearing for him?
Kumar Ravi, your lordship.
Where is he?
Earlier he was
He is for respondent number 3.
my lord.
Is for a sort of 4 and 5. My friend Ravi is appearing for 4
Yes,
and
yes.
5.
But with us, our dues, my lord, that were settled under a scheme of one-time settlement, he has himself brought on record at page 61 is the no due certificate.
At
That
page?
you have charged.
At page 61, my lord, of the writ petition. And insofar as the compliance of the judgment is concerned, my lord, on 25th September 2018, we were granted, sanctioned the amount by the industry department, and on the same date, we made the payment to the petitioner. So the interest aspect or the issue with us, my lord, goes with the no due certificate
Nothing.
of the my lord.
The petitioner, by way of the petition, has prayed for grant of interest at the rate of 12.5% compounded half yearly on the subsidy amount of 2,32,500 for the period from 6 to 1992, 16 July 1996, and interest on the subsidy amount of 5,40,100 from 6th February 1992, 15/10/2018, as there was a delay in release of the subsidy amount on the part of the respondents. Learned Counsel submits that
May I just intervene?
this
My
court
learned
by
friend-
order dated 13 January 2000. You want to say something more?
Yes, just my lord, my learned friend has not, my lords, to answer that whether he charged interest, because my lords, from 2000 settlement came in 2009. So he continuously charged interest, send demand note to us, that you have to pay, including that
That we have
subsidy.
seen.
That is.
Please wait. You will see in the order.
And my lordships, I would be obliged if my lordships, these judgments are taken note of. My lordships,
We are not saying that interest is not payable. These judgments are only to the respect that interest is to be paid.
lordships.
We are not saying that it is not payable. Please hear.
If there is a delay, my lords,
Please hear. ये क्या लिखा?
Learned Counsel submits that this court by order dated 13th July
30 January 2000 allowed the writ petition filed by the petitioner for the payment of the remaining subsidy amount which was due as in the year 1996. Stop. The court also further directed that the subsidy amount shall be sanctioned and Respondent number 5 therein shall not be entitled to charge interest on the loan amount to the extent of the subsidy amount, namely amount of rupees 7,74,000
600.
from the date the same by way of industrial subsidy had become due to the petitioner. Learned counsel submits that although the subsidy amount was not released up to 2018, the respondents continued to charge interest on the loan amount of rupees 7,74,600, and therefore the petitioner is entitled to receive the interest on the remaining subsidy amount. Learned counsel also relies on judgments to assert that interest is payable on the subsidy amount. Per contra, the respondents have filed their counter affidavit, and it has been pointed out that the state government had declared an industrial policy to revive Sikh industries and promised different subsidies to such entrepreneurs. And in pursuance thereof, subsidy was to be paid to the petitioner to the maximum of rupees 5 lakhs. The petitioner
That policy was
had,
revised in lordships, and all the 15 lakhs has to be paid by the
please
state.
don't interfere. The petitioner had set up a plant for which the BICICO, Bihar State Credit Investment Corporation Limited, had granted a term loan of 86.26 lakhs to set up the industry. The subsidy amount was also later on modified to the and increased to an amount of rupees 15 lakhs. The petitioner's firm was granted a sum of rupees 7,25,400 towards the industrial subsidy, and the balance sum of 7,74,600 could not be paid to him at the relevant time. The court, by its judgment, directed the respondent to release this remaining amount. However, the said order was challenged before in LPA, and LPA number 372/2001, which was ultimately dismissed on 6/8/2014. As regards the loan amount and interest thereto, the petitioner applied as a one-time settlement scheme 2009, and under the said one-time settlement scheme, dated 10/11/2009, the petitioner's loan account was closed. The amount of interest was also reduced considerably. In these circumstances, there was no occasion to state by the petitioner that the interest was charged on 7,64,000 separately, as it was a one-time settlement. The claim of the petitioner, therefore, for interest on the subsidy on the ground that the respondents had claimed interest on 7,64,000 is not made out. Para, I have considered the submission. There has been a delay in payment of subsidy, but this court finds that in the earlier writ proceedings, the petitioner did not press for claiming of interest on the delayed payment of subsidy. Fresh writ petition for claiming interest is not maintainable. Successive writ petitions cannot be entertained if a grievance of the petitioner, if there was any grievance with regard to non-payment of interest by the court in the earlier writ proceedings, the petitioner always had a remedy to take up the matter before in LPA or to file a review. However, a fresh writ petition for claiming interest does not lie. As regards the issue with regard to payment of for claiming of interest paid on the amount of 7,64,000, as noticed above, there is no separate charge of interest by the respondents. The entire amount of loan account has been finally adjusted in under a one-time scheme, one-time settlement scheme 2009.